Stop what you're doing. If you heard the Supreme Court just erased location-based carry bans nationwide overnight, do not bet your freedom on that headline. Because if you act on a half-true YouTube title and walk into the wrong place with your gun, you could still end up facing real charges, real court costs, and a life-changing mistake. Quick question before we continue. Are you subscribed? Because this channel exists for one reason: to keep you from learning gun law the hard way. If you want updates before the next rule change, the next court fight, or the next trap hidden in fine print, hit that subscribe button right now. Now let's slow this down and get the truth straight. Here's what just happened, and here's what did not happen. The Supreme Court did not issue some magic one-page order that suddenly made every carry ban in every state disappear. That is not where we are. But here's why this story is still a big deal. The court has already said states cannot just call every crowded place sensitive and make carry rights vanish. That warning came from the Bruen decision, and that warning is now colliding with new state laws that tried to ban carry in long lists of places after Bruen came down. So if you carry, or you plan to carry, this matters to you right now, not next year. Not when politicians finish arguing. Right now. First thing you need to know is this: Bruen changed the whole fight. Before Bruen, many states made you beg for permission to carry. After Bruen, the Supreme Court said the Second Amendment protects a real right to carry in public for self-defense. But here's the crazy part. The court also said some places can still be off limits: schools, government buildings, places with a strong historical reason for extra security. So the rule is not carry everywhere. The rule is also not the state can ban carry anywhere at once. The fight is over where that line goes. And this is where it gets interesting. After Bruen, several states did not just tweak a few rules. They rolled out giant lists of so-called sensitive places: parks, beaches, restaurants that serve alcohol, public transit, libraries, museums, houses of worship, entertainment venues. And in some places, they flipped the rule on private property open to the public. That means instead of carry being allowed unless the owner says no, the state tried to make carry illegal unless the owner says yes. Let me break down why that matters. Imagine you have a valid permit. You stop for gas, grab lunch, walk into a pharmacy, then pick up your kid from an event. Under one system, your permit means you can carry unless a place is clearly banned or posted. Under the stricter system, your permit may not protect you in many of those stops at all. You could go from lawful to unlawful just by stepping from the sidewalk into a store with no sign that clearly tells you what the rule is. That is why people are fired up. It is not just about one building. It is about whether states can make normal daily life a maze that almost no permit holder can navigate safely. And here's the part nobody's talking about enough. The Supreme Court in Bruen warned against exactly that kind of trick. The court said states cannot basically treat all public gathering places like off-limits zones. In plain English, the justices said you cannot turn an entire city into a gun-free map just because lots of people are there. That line matters a lot. Because many of the new laws looked to gun owners like an attempt to do through location bans what states could no longer do through permit denials. So when you hear the court is ending location-based carry bans, what people are really reacting to is this bigger legal war. The justices opened the door in Bruen, then states rushed through it with new restrictions. Now the courts are deciding how far those restrictions can go before they break the Constitution. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when police ask about your gun during a stop. Subscribe now so you don't miss it, because knowing the law is good, but knowing what to say under pressure is what saves people from making terrible mistakes. Now let's talk about the 2 cases that make this urgent, because here's where a lot of viewers get confused. Case number 1 is the New York fight. You may know it as the Antonyuk case. That case challenged New York's post-Bruen carry law, which created a long list of sensitive locations and heavy permit rules. Gun rights groups and permit holders argued New York was trying to sidestep Bruen by banning carry in so many places. At one stage, lower courts blocked parts of that law. Then, appellate rulings brought some restrictions back. That back and forth is one reason this area feels so chaotic. A rule can be blocked on Monday, revived on Friday, then narrowed again months later. That is brutal for normal people who just want to follow the law. But here's the key point. The Supreme Court did not hand down a nationwide emergency ruling in Antonyuk that ended all location-based bans. In fact, the later petition in that New York fight was denied in 2025. That means if someone tells you New York went up and the Supreme Court nuked all carry location bans for the whole country, that is not accurate. Now don't miss what that denial does and does not mean. It does not mean the justices love every New York restriction. It does not mean every sensitive place rule is safe forever. It just means the court did not use that petition to settle the whole issue for everyone at that moment. Now this is where it gets even more important. The case that really puts this fight front and center is Wolford v. Lopez. That case came out of Hawaii, and it was tied to a similar challenge involving California. The issue there is huge. Can a state make it a crime for a licensed concealed carry holder to bring a handgun onto private property open to the public, like a store or restaurant, unless the owner gives express permission? Read that slowly, because this is the part that shocked me. Not if the owner posts no guns, not if it's a courthouse, not if it's a school. We are talking about normal businesses open to the public. That question went all the way up, and the Supreme Court agreed to hear it. The case was argued in January 2026. That matters because argued means the justices heard the case on the regular merits docket. In simple terms, this is a full-dress review, not some secret nationwide emergency order that instantly rewrote every state law overnight. So if you saw a video saying, emergency decision just ended all location bans nationwide, slow down. The real story is still serious, but it is more specific. The court is being asked to decide how far states can go with these sensitive place lists and private property default bans. That could reshape laws across the country. But until the court actually issues a final ruling, your state law still matters. Your local posted signs still matter. Your permit conditions still matter. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Here's a hypothetical example to explain this. Say you live in a state that follows a strict private property rule. You carry into a coffee shop with no clear sign on the door. You assume silence means carry is allowed. But under that state's rule, silence may mean the opposite. You might already be in violation the second you cross the threshold. That is why this case is such a big deal. It is not about some rare edge case. It is about ordinary everyday movement. Second, think about travel. Most people think, I have a permit, so if my permit is recognized, I'm covered. But the truth is, location laws can get you long before permit recognition does. You can be legal to carry in the state and still illegal in the bus station, the stadium area, the bar section of a restaurant, the park, or privately owned business that falls under a special state rule. That is the trap. Third, remember this word, injunction. That just means a court order stopping a law, at least for now. When you hear someone say, the ban got enjoined, that does not always mean the fight is over. It may mean the rule is blocked while the case continues. Then an appeal can change it again. That is why old advice is dangerous. A video from 6 months ago can get you in trouble today. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who come here first when a court ruling drops, a state changes its carry map, or a legal rumor starts spreading online. Hit subscribe, because the worst time to learn this stuff is after you've already made the wrong move. So what should you do with all of this right now? Here's the practical part, and this may be the most useful section in the whole video. First, stop trusting broad claims. If somebody says, the Supreme Court just made carry legal everywhere, that is a red flag. The court does not usually work like that, and gun law almost never works like that. Even when the justices do step in, there's still a messy period where lower courts and states fight over what it means. Second, separate 3 different questions in your mind. Number 1, can you legally carry in that state at all? Number 2, does your permit or permitless carry status cover you there? Number 3, is that exact location banned anyway? Most people only ask the first question. Smart people ask all 3. Third, watch private property rules like a hawk. This is where many people could get burned. In some places, a business has to tell you no. In other places, you may need express permission before you carry inside. Those are opposite systems, and mixing them up can be a disaster. Fourth, pay close attention to places that sound harmless. Parks, beaches, public transit, museums. But these are exactly the kinds of locations being fought over in court. Here's what most people get wrong. They think only obvious places matter, like schools and courthouses, but many modern fights are about everyday places. Fifth, do not assume a lack of metal detectors means carry is lawful. That is a huge mistake people make. Security presence and legal status are not the same thing. A place can be totally open and still be prohibited. Imagine you're at a traffic stop, and the officer asks where you're headed. You say you're taking your family to a festival, grabbing dinner, then stopping at a friend's business. Sounds normal, right? But you just described 4 separate location questions in one evening. That is how fast this gets complicated. Even if the Supreme Court rules strongly, that does not mean every place becomes legal. Some categories may survive, some may fall. Some states will rewrite laws the next week, others will drag their feet. So the smart move is not to celebrate too early. The smart move is to stay sharp. The urgent part is real. The oversimplified headline is not. The court is in a fight that could limit how far states can go with sensitive place laws and private property bans. But as of right now, do not act like every location-based carry restriction in America is dead. That mistake could cost you. This information could be outdated the moment the next opinion drops. Subscribe right now because I will break it down for you. The Supreme Court has not handed you a nationwide green light to carry everywhere. It has opened a massive legal battle. Your job is simple. Don't trust hype, don't guess, and don't confuse a pending case with final law. If this video helped, subscribe now and stay with this channel because the next ruling could affect you tomorrow. One last simple disclaimer. This video is for education only. I'm not your lawyer, and this is not personal legal advice. Always check your current state law and talk to a qualified attorney if your freedom is on the line.